our podcast. This is George of The World According to George. And today joining me is a very experienced attorney who has been on both sides, has been on the defense side and as a prosecutor. I'm talking about Randy Neal. Randy, tell us a little bit about your legal experience so that our listeners can understand that they're dealing with someone with a lot of knowledge about the law.
Well, that's a tall order. Well, I've been a lawyer now for 20 years. I actually started my prior career. I did about 20 years in law enforcement. So together, it's been 40 years, and I've done, like you were telling, I've been both private practitioner, so handling plaintiff's work and defense work, and for private clients, and then I've also been a government prosecutor, both for the state and for federal. So, and then I was a federal law enforcement officer for many years.
Well, thank you for joining us. The topic of today's podcast is the case that the prosecutor in Manhattan has brought against ex-President Donald Trump. This is an unprecedented situation, and our objective is not political. Is simply to analyze the merits of the case as we know them to be so far. So, what we know is that there are 34 counts of document falsification. Would that be accurate?
Yeah, they're all identical. There's no difference between the first count and the 34th. They're all technically misdemeanors that can be enhanced under New York law if there is a criminal nexus to it. And so they're otherwise just the 34 misdemeanors. The prosecutor in this case has tried to, or is alleging, to connect it to an improper influence on the 2016 presidential election.
Some interesting issues with this case are, number one, the DOJ, Department of Justice, rejected prosecuting. Am I using the proper terminology?
Declined. Yeah, normally, they would decide whether to accept or decline prosecution based on an investigation being provided to them.
And the Federal Elections Commission also declined to do anything regarding the accusation of using campaign funds for personal use. Is that also accurate?
Yeah. So, my understanding is that these were not campaign funds, that they are saying they were business funds, and therefore under New York law, they're saying that the records that were kept about these expenditures were in some way fraudulent, false.
My question, and is a question that many have, irrespective of which political side of the aisle you're on, is that the statute of limitations has already taken place, has already passed for misdemeanors by not 1 or 2 years, but quite a few.
Well, and I would imagine it's actually passed for a felony as well. Now, this is New York law. And so Idaho, our statute of limitations for felonies is 5 years. For a misdemeanor, it is only 1 year.
I believe New York is 2 for misdemeanor and 5 for a felony.
I'm seeing that right now. Is just a quick look at the law as I've looked it up here is 5 years for felonies and 2 years, and so this is about something that happened 7 years ago. Now, what the state will have to do in order to survive a motion for dismissal is they would have to show that under New York law, the statute of limitation is tolled. And here in Idaho, that's any time somebody leaves the state. So if a person is 5 years in the state of Idaho and we don't bring a prosecution, then it's done. That's statute of limitations. So I think what they're arguing in the New York case is that during the 2016 to 2020 period, or 2017 to 2021, that because he was serving as president, his residence was at in Washington, D.C. at the White House, and he was not in New York. But I think the counter argument would be if you're in the military and you get assigned, stationed somewhere, you can still maintain residence in a different place. So if the defense could successfully argue that his place of residence was actually in New York, then the statute of limitations would apply and there would be no tolling. What the state is hoping is they can say that while he was living outside New York, that time doesn't count.
But it is established, at least I believe, that most people would consider the fact that someone is living at 1600 Pennsylvania Avenue, that is not a permanent residence.
No, it can't be. It's owned by the government, right? So he doesn't own real estate there in Washington, D.C. It's like, to me, it's more like a temporary station that you would get in the military. You go to Hawaii and you're living in Hawaii at the base. You don't own the base, but for certain purposes, the law would say somebody who's under those circumstances is not a resident. And what they're, I think, hoping to argue is that maybe he was a resident, who knows, New Jersey at his golf club there, or Florida. But it's pretty clear he owns some pretty substantial property up in New York. And I think part of the argument would be based on where he potentially paid taxes. Here in Idaho, of course, you have part-time residents who still have to pay taxes in Idaho, even though they may be living somewhere else for part of the year. So things like that will go into the analysis of, is he a resident of New York? Is he a resident of somewhere else?
But whether he was residing in Washington, D.C. or New York, one of the elements that seems to be missing is the fact that there is no nexus between a misdemeanor and a felony. What would that be, given that even the accuser, well, not the accuser, but the primary and most important witness, Michael Cohen, who was Trump's former attorney, said that he was with the intent of basically hiding an issue that would come out during the campaign, but then he said, and hiding it from his family. So even to be a campaign fund violation, it would have to be exclusive to campaign violation. Is that not accurate?
Well, so they've got to first prove that the record was false, and so I don't know if they'll, have that hard of a time proving that this was not for legal fees. But there is a proof issue that they would have to show that he knew when he wrote the check to a lawyer that it was not for legal fees; it was going to be used for something else. I am unaware of what evidence they may have that in providing money to his lawyer, that somebody's going to testify he knew that was to keep the story from coming out. But the second part of that, in order to go from it's a false record, which is a misdemeanor, up to a felony, then they would have to show that false record was utilized for some violation of law. And the theory so far, and we haven't got really specifics from the Manhattan DA about this, is what is the law, specific law, state or federal, that they're saying he used this money to violate. And I think what they're saying is that he attempted to use this money improperly to influence the election. I'm concerned that's a pretty serious stretch, because if you don't want something embarrassing to come out, sure, that might be something that a person would consider when they're voting. But when we talk about influencing an election, just to not put your negative stuff out there, I don't know if that meets any of the requirements of the law. Typically, when you're using money to influence an election, you would be using it to, pay people to vote for you, to use money to influence, the electorate in some improper way. But the fact that you don't want something negative to come out, well, that's every politician, every election.
How does assuming that there was a violation of federal election law, what gives the prosecutor in Manhattan, New York, jurisdiction over such a case?
Right. So they're basically going to have to show that the defendant, Mr. Trump, was sitting in New York writing checks and uh, and making false disclosures or records in his business, which is in New York. So the jurisdiction, theoretically, I guess, could just come from the fact that the Trump organization is centered. Its operations are headquartered there in New York, and so the theory for jurisdiction could be that they are regulating a business that exists in New York City, in Manhattan. And I guess it wouldn't matter if your CEO was on vacation in the Bahamas. If he was falsifying records, that would be something that would be part of the business itself, business operation itself. Um, but yeah, that I mean, we've been on just a couple of minutes here, and we've identified three major issues that I think that the prosecution is going to have to overcome if it's going to survive a motion to dismiss.
Speaking of motions to dismiss, one of the things that has been known, because it's been public for years, is that the district attorney, Alvin Bragg, ran and made a campaign promise that he would go after Donald Trump.
Right.
Does that affect anything on motions before the judge to dismiss?
Oh, unquestionably, you're going to see affidavits and probably, excerpts from news articles, potentially campaign materials, all these kind of things showing that there was an improper bias to the decision. But when it comes down to prosecutorial bias, the prosecutor is always biased against someone who is committing a crime. We're on the opposite side of the aisle from a defendant. So it doesn't necessarily mean a conflict of interest automatically. But for him to have said as a private citizen and candidate that he intends to target another private citizen for prosecution if he comes in, it certainly raises issues of a political nature, if not of a legal nature. But the remedy for that is going to be for the voters of Manhattan to hold him accountable for any biases or the ways that he went about business. And as you can see from the prior election, which he won, the voters of Manhattan aren't necessarily against the idea of the prosecution. So he may not be held accountable for that at all.
Would the defense file for a change of venue, given the fact that the prosecutor made promises and the electorate has helped him fulfill that promise?
Yeah, I think the reason you see that the next court date is so far out, which is, December, is that they expect this pretrial motion practice to be pretty extensive. So as a defense attorney, I'm not going to go to the very, I certainly don't want to be in the place where the person who ran on the platform of, I want to get a specific person and prosecute him, where that represents the majority of voters, right? At least that we have to assume there was some significant influence. And then secondly, just the number of people who are aware and have become, that have this pretrial publicity that are part of New York City. I would think a change of venue is really demanded. And a step further, they could make a motion to disqualify the prosecutor and ask for a special prosecutor to take his place.
One of the things that Donald Trump is not known for is restraint insofar as what he has to say. He has also made statements that have been rather problematic regarding the judge assigned to the case, an issue that the defense attorneys could have to deal with. Or does it benefit the prosecution? Or does it benefit anyone or not benefit anyone at all? What is your experience?
Right. I've seen two reactions to this kind of thing. One is that the judge uses it as a reason to get out of the case. So if there was some concern that the judge was going to become the focus of the case because of something he has said in the past or views he's expressed privately, um, I think that the wise jurist will remove themselves from that controversy because you don't want the judge to be the focus of the case. It should be the evidence and not necessarily the prosecutor or the judge that's handling it in a perfect world. So recusal is one possibility, and then of course disqualification is the other, and that's a much higher issue. But even if if you make a motion that says the judge is biased as a defense attorney, you may not even expect that that's going to be granted. But what you're doing is kind of making the judge somewhat sensitive to the idea that he's perceived as less than unbiased. And in that case, you may get a judge who's much more careful about his decisions. And and so in the case where he's saying, okay, you're biased against the defendant, it may actually make him want to show that he is in some way fair and showing that he's making decisions, straight down the line or even favoring the defendant a little bit. And I've certainly seen that in practice here is that, it's just a way that when you've got a judge who is ruling often in favor of, and it's usually the stronger case, then by stating that you think that the judge is biased, even if it doesn't result in him granting that and recusing himself, a judge will be sensitive to that because he doesn't want it to go up on appeal.
Were you to be the defense counsel, put on your defense counsel hat, what would you be doing between now and December? Would you start with motions? And if so, what would those motions be? And then I want you to put on your prosecutor's hat and tell me how you would defend those motions.
Yeah, I think we've talked about at least 5 now. One is jurisdictional. One is has to do with bias of either the judge or the prosecutor. The fourth one would be about the legal sufficiency of the charge itself. The fifth, I would be making a motion for more specificity as to the charge because the prosecutor's theory is not fully exposed. We really don't know what conduct or at least specific conduct that they're trying to connect to the misdemeanor. And I think even without those motions, one of the real challenges for the prosecution is you have to prove 2 crimes. So you don't only have to prove that the payment was made and it was recorded wrong or fraudulently or falsely. You have to show that he committed another crime. And as we talked about at the very beginning, other folks that have looked at those particular crimes that could be associated with these false records have declined to prosecute. And that can be, there's smoke there, but they felt there wasn't enough to get beyond a reasonable doubt. So that part is really for trial. If we get to trial, I think as a defense counsel, I would definitely be forcing the prosecution to prove up that second crime and make it so it's really a double trial and twice as hard for the prosecutor.
You're talking about the nexus between a misdemeanor and a felony.
Yeah, to make it, you'd have to prove a nexus between the misdemeanor conduct to a felony, or not a felony behavior, but a criminal behavior that would meet the standard for New York law to enhance that misdemeanor and make it a felony. So as a prosecutor, it's too late. If I haven't got my act together before I make this kind of a charge against a former president, This is not the time as a prosecutor to be trying to figure out how I'm going to defend against these motions. I you know, if it is entirely political, I can see, a politician, bringing a charge and then not caring if it's going to be successful or not, but it follows up on a promise he made, right? If if that's true, I mean that really is unethical, because a prosecutor should not take a case forward that he does not believe meets the standard of beyond a reasonable doubt. So,
Is Alvin Bragg running the risk of being accused of prosecutorial misconduct?
no, in most states, prosecutors have absolute immunity for prosecutorial discretion, for decisions made under prosecutorial discretion. So the standard is, there's what we often hear is qualified immunity. Qualified immunity is, as long as you're acting in good faith, then you can't be sued for those things that you're doing that are within the scope of your assignment and your duties. But with prosecutors, because otherwise, prosecutors can be accused of bad faith, in every case, which would tie up the prosecutor half the time prosecuting criminals, and the other half defending himself against charges that they weren't brought, appropriately. And so in most states, there's absolute immunity for prosecutorial decisions, and it even if it's ultra vires, basically a bad faith decision by a prosecutor is not something he can be civilly liable for. He can certainly be ethically, in trouble with the state bar. And we have seen that where somebody who was found to be prosecuting in bad faith was disbarred and they lost their law license. But as far as civil or criminal liability, it's pretty difficult to overcome absolute immunity.
Former President Trump has a very experienced and knowledgeable defense team. Will this reach trial at some point, or do you believe, based on what we know so far, that the motions will be accepted, including perhaps one to dismiss?
Yeah, I would have to know a lot more specifics, and I'd have to be on the inside of the Manhattan DA's office to have all of the information that I would need. And I'd have to be a New York State, practitioner to really understand, the ins and outs of that state's laws, in order to answer, are they going to get to trial? I strongly believe that there will not be a plea agreement in this case, although that would be, if this had been, John Jones, who works for, a stockbroker, in Manhattan, and they had accused him of these misdemeanors, a defense attorney would have gotten a plea agreement for misdemeanors every day. But this is too high profile a case and everybody's reputation is on the line. And so I can't see them reaching a plea agreement where the President Trump would, accept that he did a misdemeanor and do a $50 fine. That would be a strong victory for just, his reputation taking the hit and Bragg doing a prosecution of some kind.
Well, let me, I'm sorry, didn't mean to interrupt, but I have a question insofar the attorney-client privilege with Michael Cohen, who is the prosecutor's star witness.
Right.
What happened? How did that not hold up, that privilege?
Yeah, you can't use an attorney as an accomplice and claim attorney privilege. So one way of defeating attorney-client privilege is to engage in a crime. So it's the difference between I committed murder, you're my lawyer, and I tell you where the body is. Then that's a attorney-client privilege all day long. And the difference between that and the difference between you as my attorney driving your Lexus with the body in the back trunk out to the place we're burying, then at that point you stop, you go outside the scope of being an attorney giving advice, and you're now a co-conspirator in a criminal enterprise. So there's some murky lines there where I'm sure President Trump could claim that they're trying to get conversations out of Michael Cohen that are protected by privilege, but any criminal acts, that's not lawyering. So attorney-client privilege is something that applies to communications. And when you start talking about actions, then it doesn't typically, unless, again, that action is related to communication, it doesn't fall under that privilege.
You worked in Washington, D.C., so did I.
Yes.
And politics prevail over everything. I have
Sure.
to ask you your opinion on one thing, and again, it's not a political question, but one having to do with the law. Has the judicial process been hijacked and used as a political tool? I was going to say a political weapon, but I think that would be inappropriate. Has it been politicized? Has it been turned into a tool for political objectives? I think back not necessarily to Donald Trump. I mean, he is a polarizing figure, someone who has a very bombastic personality. I think we would all agree to that. And has engendered the dislike or even hatred of many people. But I go back to the days of Judge Bork when he was being confirmed for the Supreme Court. And it seems that during that time, things changed. The decorum, the civility that used to prevail in the Senate in particular. Have we sort of come to a point where the law or the use of the judicial process has evolved into a political tool for either one or both parties?
Yeah, I think so. I think we look at what happened perhaps in Watergate. And at that time period when I was growing up, if there was a political scandal or if a politician was caught committing a crime, the first thing they did was resign. You got me. And for the good of the government and good of the public trust and the integrity of the institution, I'm going to resign. So we saw many resignations. Of course, Nixon was an exception to that, who fought for a year and a half, eventually resigned.
Well, his vice president, Spiro T. Agnew.
Sure. And that's a good example. He got caught and resignation, and then Rockefeller was put in, and so forth. And even at that time period, just because of the effect that it would have on the nation, then Gerald Ford pardoned Nixon and put the entire issue to sleep, so that our institutions and our country would not be further torn apart by further investigations and so forth. Well, contrast that in the 90s when you've got a president who gets caught, making false statements, and you've got a president who absolutely refuses, and they go to an impeachment, and the impeachment fails, and he remains president, despite what seems to be some pretty serious misconduct. And that, I think, kind of reset the expectations for politicians that they could actually stay in office. And even here locally, we've seen occasions where local public officials were charged with serious crimes, and there were calls for resignation and so forth, and they simply stayed in office and rode the wave. And so when you start looking at President Trump, for example, being impeached, twice. Yeah, you have to ask yourself, was this, in retaliation for the impeachment of Bill Clinton? And so these were extraordinary tools that the founding fathers felt would be used in the most serious of crimes. And I mean, some of the things that were brought up, I don't think that the survival in the Senate was simply a matter of, that there wasn't sufficient evidence, or there were the Republicans had a majority, whatever other reasons could be, other than the fact that this was not what was envisioned when the founding fathers considered what would be necessary for impeachment. Well, this is kind of, after the fact. I mean, 7 years after the fact, an impeachment type approach with a much less significant political protection against it. Right? We don't have a Senate. We don't have, dozens of decision makers. It's down to a small group, one person really who could make that decision. You have one judge. I mean, these things that have this kind of effect on our institutions, like the presidency, I think have to be taken in the most solemn of way. The decision making has to be done in the most solemn way, saying, yeah, we may talk about the rule of law as it applies to President Trump, but really the question becomes: Are we using nitpicky misdemeanors to try to score some kind of political accomplishment? Now, whether Bragg is interested in fulfilling his campaign promise or preventing a second Trump presidency, who knows? But the timing is very suspicious.
Well, it has been a fascinating conversation. Randy, I truly appreciate you sharing your knowledge. Many of the questions and issues that we've covered in this podcast are questions that many have articulated to themselves, to family, but have not had an opportunity to speak with someone with the knowledge of the law that you have brought to this podcast. So thank you so much. I hope that we can come back to you. We have a couple of interesting cases coming up in Idaho where we happen to be. One of them, obviously, the Lori Vallow case, which is about to begin, and another one having to do with the horrible murders in Moscow, Idaho. So I look forward to having you on our podcast again, and can't thank you enough for joining us in The World According to George.
I hope you don't mind if I add, I'm impressed with your research. Your level of understanding of these legal concepts is very good, and I think your listeners benefit from that. So I have to give you a nice well done as well. Thanks, George.
Well, thank you. It'll be until next time. For now, thank you for joining us in The World According to George.